the ranking member on the Constitutional, Legal Affairs Committee of Parliament. He's joining us on the line. Sir, you're welcome to Eyewitness News.
Hello.
Can you hear me, sir?
Yeah, now I can hear you.
Great. Good evening. You've called a press conference. You've threatened, based on what you've said, to challenge the Attorney General's discontinuation of the case in court. Can you explain, you're a lawyer, why the Attorney General's filing of nolli prosequi is going to be a subject of litigation in court? The Constitution is clear on that, isn't it?
Yeah, because the number of things that I raised, one of them was a conflict of interest. If he was acting as a lawyer or the accused person and you become an Attorney General, then all you can do is to argue in favor of your people and file a nolli prosequi. Nobody owes him an explanation that he should come and explain to us. But because he chooses to explain it, because he says that he wants to be transparent, so we want him to be more transparent. That's all.
Okay, so let me understand this. The Attorney General can file nolli prosequi without explaining.
Yes.
He has decided to explain, and you are saying that the explanation is not satisfactory, so he should go ahead and give some further explanation. What if he goes to court and simply tells the court, my lord, based on the decision of this, based on the provisions in the Constitution, I'm actually supposed to stay mute, so I choose to stay mute. That's the end of the case, isn't it? It's as simple as that.
Yes. Let it be the end of the case. Then we will know that ever since he became the Attorney General, he's picking and choosing cases he would want to prosecute and cases he doesn't want to prosecute.
But that's always been the case,
Sorry?
That has always been the case without any apology to anybody.
They didn't allow me to land.
Please go ahead.
And now those people who are in his administration, he is defensive. Because the amount that the old Attorney General had claimed, the 5.7 billion, he is now claiming that it is not up to that. And it was just paperwork. Where whole Attorney General, when we are talking about fraudulent, fraud, dishonesty, causing financial loss, breach of financial trust, he doesn't see anything serious about that. And that is because the person is his client. And he's using the benchmark for civil procedure to more or less conduct a criminal jurisprudence. And what he's doing is unknown to us. There are laws that govern that. For instance, there is a section 35 of the Courts Act. There is a court, and there is a plea bargaining act, and it tells us that he doesn't want to use any of them, and he didn't use any of them. And I think the justification that is given, he is wrong to say that on my own I have negotiated with the parties. Which parties? You were representing one or two, and then you turn around to say that, look, this is the best for the nation. I don't think I can agree with him.
So the redress for you would be that he does what exactly? Goes for more money, or comes to explain why he's taking small money? Or what exactly would be redress for you?
If you had followed the argument, all we are saying is that if you want restitution, there are laws that govern us. The plea bargaining under our section 162 as amended is clear on that. Apart from that, the Courts Act section 35 is clear on that. And if you want to go and you are aiming at getting money for the state, mind you, one of the theories of punishment is deterrence. So sometimes you just don't look at the individual and say that in the best of the, and it uses the proverbial theft of a goat. So what happens? He's talking about 60-40. We are not even sure that he has retrieved the 60%. He says that he's going to make sure they get it and pay it But in the case of the same banking center, Scroll, the court said that pay 1/3. Why didn't he allow the court to supervise what he's doing, and he's so moto doing it on his own? So once he chooses to tell us the reasoning and he wants to be transparent and he's wrong, we have to respond to that.
I see. What do you think of the school of thought that says, listen, what's the point of sending people to jail when we can take some of the money from them? At the end of the day, we send them to Nsawam or wherever and take care of them. And there's also even a possibility that we may lose the case at trial. So if the person is willing to negotiate and pay some of the money, why don't we take that and walk? Our consolidated fund benefits,
right.
and everybody's happy.
But there are procedures, the legal procedures of doing that. There are processes. And I've already told you that the Cause Act, Section 35, does that. And then the Plea Bargaining Act does that. But he did not he did not go under any of these processes. Because that one doesn't say that convict the person and put him to prison. That one says that let the court supervise. And there are a number of things you can do, for instance, under the Plea Bargaining Act. The court never, and the laws don't say that because you are Attorney General, so moto, you can decide to do whatever you want. No, you must go in accordance with law.
And so for you, the law. Okay, I'm trying to still understand. Is it
there
conflict?
Are not. What I'm saying.
Is it conflict of interest you are raising, or you are saying this information is unsatisfactory?
The conflict of interest is one, and it's giving rise to the Attorney General not going in accordance with the law. There are laws that help us as a nation to do restitution if you want to go by that. There's nothing wrong with that. But this one, let us retrieve the amount. That's why the plea bargain is also there. Let us retrieve substantial part of it. But now he comes out with a new principle. This is national issue. And the new principle he has brought is 60-40. When somebody pays 60, let us forget about the 40. Under what circumstance? Who supervised it? What law did he use? I am not comfortable, and I want him to come out and explain to us better.
As Minister for Justice, can he not do what he believes is in the best interest of justice?
Why did he explain? He could do that.
No, perhaps I'm saying that on the policy, could he say that as Minister for Justice, this is a new policy he thinks is in the interest of the nation, and that's what he's going to pursue so far as he remains Attorney General?
No, he can't do that. When you are the Attorney General, what you have to do when it comes to law, you have to bring it to Parliament. But that's all the point we are making. We have not
even if it's a practice direction for his office and officers, he still needs to go to Parliament.
My brother, the office is not his private office. It is the Attorney General's office and the Minister of Justice for the whole nation. So what is act for the nation is what we are talking about. It's not, you don't make laws from your pocket. To say that when I look at the civil aspect of it, it's better I retrieve the money. That's not what the law says.
And you said something that he's using civil procedure to prosecute criminal procedure. Can you explain that?
When he himself said it, when he was doing his press conference, he himself today, he said it. He said when they asked him whether he used the existing laws, like the plea bargaining, he said no. I didn't go by the plea bargain. But when I look at the civil aspect of it, it was prudent for me to negotiate with the parties. And that was what he did.
Very well. Thank you. How far are you willing to litigate this issue?
And so far as I get my strength, we have to point the wrong thing out so that the right thing will be done for the nation that we all live in.
Thank you so much for speaking to us.
My pleasure. Right.
That's Honorable Kwame Nyimedu Entry. He is NPP Member of Parliament.